Colleen Palmer, and I head up the risk management program at Beazley Group. And a big part of my job is reviewing contracts from a risk management and professional liability perspective for our policyholders, our architect and engineer policyholders. So this is one of my favorite topics to talk about, and we are going to get started. I know we were scheduled to finish at 3, so we will still finish at 3. We'll just move a little more quickly, no problem. So some of you may have been on the webinar that we did a few months back, and I just wanted to briefly recap what we spoke about then. And we talked about the 5 topics here on this screen, and 2 of them, standard of care and indemnity, we're going to repeat talking about today because they are such important topics with respect to negotiating your contract. We'll do a brief recap on the other 3. Scope of services is an absolute critical component to make sure is sufficiently addressed in your agreement. You want to make sure that your scope is really detailed and defined and consistent with discussions that you've had with the client, and also consistent with any proposal that you've submitted or RFP or RFQ that the client has submitted. You want to avoid what I call unlimited or absolute scope. So if you see words like you'll provide all services or complete services or each and every or all necessary, all those types of words really expand what your scope can be. And if there's a disagreement about something that the client thinks you should be providing, and you say, well, we never thought we were going to provide that. And they said, well, look, right here in the contract it says that you are going to provide each and every service necessary for the complete and fully operational project. Well, that's a pretty good argument that your scope is probably more expansive than you originally intended. So you want to make sure you have a scope of inclusion, meaning you're going to detail and define all of the services that you are going to provide. And then to the extent that you know at the time of contracting, a scope of exclusion, meaning you're going to say excluded services include but are not limited to, and then you're going to list the things that you know you're not going to provide. You don't want to have just a scope of exclusion, because when you think about it, you'd never truly be able to list in the universe all the things you're not going to do. So inclusion, and then to the extent that you know, exclusion. Incorporation by reference. This is inherently a risky proposition because any document that is referenced in your agreement as being incorporated into your agreement effectively is stapled to your agreement. So anytime you see a document language saying something is incorporated, you must make sure that you obtain that document, read it, and make sure that it's acceptable. Lots of times a prime agreement will be incorporated. That's probably the most common thing. And there may be provisions in that prime that are either inappropriate or inapplicable to you. So we recommend that you have some language in your contract saying that in the event of discrepancy between the 2 documents, your agreement will govern. So look out for words or statements saying that in the event of inconsistency, the prime will govern. Or what I don't like also is saying in the event of inconsistency, the more stringent or the higher requirements or the more expansive requirements, that kind of language will govern. That can get you into trouble. And then lastly, dispute resolution we chatted about last time. We recommend that your disputes be submitted to non-binding mediation as a condition precedent to litigation as the binding dispute resolution mechanism. And clients sometimes like to use arbitration. We at Beazley have found in an examination of our claims over the years that litigation can and does produce more favorable results. Some of the inherent downsides to arbitration are that it is binding. So unlike mediation, where at the end of the day, if the parties don't reach an agreement, you can walk away and then proceed to litigation. In arbitration, there is going to be a decision, and you are going to have to live with that decision, which leads me to the second big problem with arbitration, in that it is generally not appealable. Unlike litigation, where you have rights of appeal, in arbitration, appeal rights are extremely limited and generally limited to things like fraud by the arbitrator. So you're kind of stuck with this opinion. It can be arbitrary. Sometimes arbitrators look at what the arguments are and they say, well, let's just split it down the middle. You'll be responsible for half, despite any good arguments that you may have. And then lastly, rules of evidence and discovery, which you would certainly have in litigation, you may not have in arbitration. So we like to see mediation, which if the parties go into with good faith, often has very nice results the parties can resolve. And then if they can't, then proceed to litigation. Okay, so today, like I said, we're going to talk again about standard of care and indemnity, and then we're going to speak about these three topics below. A quick step back to think about contracting, and this is an area that we'll go quickly through. The contract is probably the most important document in the project, and at the end of the day, it really is this risk-reward balance. Does the reward that you're potentially going to receive from taking on this project make sense given the risk that you're going to have to take on for this project? The contract is where you're going to have your rights and the client's rights and obligations defined, and it sets the tone for the relationship. If the contract negotiations are just really difficult and the client is very unreasonable with respect to things like including warranties or making you take on an onerous indemnity, then that can be foreshadowing of the relationship to come. Obviously, you want to have a written, executed contract, no oral contracts, no handshakes. Those days are gone. It really should be written. It should be executed. And ultimately, trust your instincts. I talk to people regularly when a project is having issues and they say, you know, I kind of knew right off at the beginning. I just had a feeling, you know, it wasn't going well, and I just had a gut feeling. And what we say to that is, trust your gut. It's no science involved here, but if you have an instinct or a feeling that this is not going well, you're probably right. It probably isn't going well. So sometimes the best project is the one that you don't take. Okay, standard of care. Yes, we are still talking about it, and the reason that we're still talking about it is because clients continue to try to elevate inappropriately your standard of care to something beyond what is the negligence-based standard of care. So on this slide, we've got both the Black's Law Dictionary and our standard of care language. And we can probably all recite this in our sleep, but essentially you should be judged by what your peers are doing when they're performing the same services at the same time in the same place under the same conditions. Watch out when you see warranties, guarantees, certifications. Those types of things elevate the standard of care, and they're not covered by professional liability insurance. Not just a Beazley thing, that's consistent with professional liability insurance, that warranties, guarantees, and certifications are beyond what the policy is designed for. Superlatives, saying that you'll provide the best, first rate, first class, world class, nationally recognized, state of the art, all those types of phrases elevate what is expected of you. These next two I always like, and you see them a lot, that you'll perform to the satisfaction of the client and or in accordance with the client standards. Well, both of those things are very subjective, and the fact that they're being referenced in a standard of care provision in your contract, you can bet means that that's beyond what the negligence-based standard of care is. So you want to look out for those and delete that type of language. Lastly, fiduciary duty obligation. This is something that we could spend quite a bit of time on, but for the purposes of today, it's important to know that sometimes you'll see a statement that flat out says that you agree to take on a fiduciary duty toward the client. But more often it is language saying that you, quote, accept the relationship of trust and confidence. And that's the same thing. So what is this fiduciary duty? It's the highest duty that you can owe another. And it's appropriate in relationships like a trustee or a guardian, but it's inappropriate as a design professional. So if you see that language, delete it. I also like to add an express disclaimer saying that nothing is creating a fiduciary duty toward either party. All right, indemnity. Indemnity is probably the most difficult, certainly one of the most difficult provisions to negotiate in contracts, and it's one that can really completely negate a project for you if the parties can't agree upon the indemnity. So what is it? In the simplest definition, indemnity means to pay, and it's typically you paying the client. A more formal definition is that it's an agreement whereby one party, usually you, takes on the liability of another, your client, in the event of a loss. When I tackle these indemnity agreements, in my mind I break them down into three issues that I have to address. And this is a picture that kind of goes over that. So the first is, who are the indemnities? Who are these people or entities that you're being requested to indemnify? It should be limited to your client and the client's officers, directors, and employees. The problem is the laundry list that clients like to add as part of the definition. So it can include anything from lawyers, contractors, lenders, assigned, successors, parent companies, subconsultants, third parties that are undefined like agents or representatives. All of those third parties are either too broad or you don't have a contract with them. So you really should not be required to take them on as an indemnity. Next is whether there's a duty to defend. And if you see the word defend outright, then clearly that's a duty to defend. Look out for the word protect also, because if you look protect up in the dictionary, one of the definitions is defend. So you certainly are going to want to delete those express obligations to defend, keeping in mind that ultimately it is a business decision whether you take on that duty, but if you agree to keep it in your contract and it is triggered, that's something that's going to be an out-of-pocket cost for you because it's not covered by professional liability insurance. Some clients will leave it in. They've done their risk-reward balance, and they know that if that is triggered, then that's going to be a cost that they incur. We do recommend that you take it out, though. The third component, and the critical component from a risk management and professional liability perspective, is that the indemnity should be appropriately negligence-based. And I put the word appropriately in there intentionally because sometimes you'll see the word negligence somewhere in this, could be 3-page long indemnity, but it might still be too broad to be covered under your policy. So the magic words that we like to see are that you will indemnify for damages to the extent caused by your negligent performance of services. Anything that says you'll indemnify for intentional acts or acts, errors, and negligent omissions is not appropriately negligence-based because the negligence is not modifying acts, errors, or omissions. Lately, depending on how bad the indemnity in the overall contract is, I like to just say to the extent caused by the negligent performance, as opposed to having this potential argument later on of, is negligent modifying acts or omissions, or just negligent acts and errors and omissions is not being modified by negligence. So in indemnity, it sounds picky, but punctuation and placement of words is critically important. So you have to slow down when you're negotiating these provisions to make sure that they're acceptable. Okay. I put this slide up because it's an example of an acceptable indemnity provision. And you can see that it's got our magic words in pink, and it's limited to indemnifying the client. Here's a little cheat sheet that summarizes the things that I was talking about in the first 4 bullets. And then the last 2, let's talk about for a minute. Sometimes you'll see a mutual indemnity provision, and it may be broader than we've been talking about is appropriate. Clients sometimes will argue, hey, this is mutual. We have the same obligation to you that you have to us, so why are you worried about this? This is good for both of us. And my answer to that is that more often than not, you are the one who's going to be requested and required to indemnify the client, not the other way around. So I don't have a problem with a mutual indemnity, but if you do see a mutual indemnity, you still have to make sure that your obligation is appropriately narrow, considering the 3 main concepts that we discussed on the prior slide. Incorporation by reference, same thing with the conversation we had about incorporating documents by reference. You will see sometimes in indemnity provisions, it'll say that you agree to take on the same indemnity obligation that your client has in its agreement, in the prime agreement. And that can be problematic because, well, number 1, you may or may not have the prime agreement, so you have no idea what it says. And number 2, if you do have the prime agreement, it might be too broad. So you want to make sure that, again, whatever's incorporated by reference is acceptable, and particularly with indemnity, I don't even like to have that reference to indemnity of whatever's in the prime or documents incorporated by reference, because if you missed an indemnity in whatever the document that is, it's incorporated by reference, then arguably you've taken it on. So I do like to delete that and make sure that the provision in your agreement is acceptable. Okay. So now we're up to the first of 3 sections that are new to this webinar today. And the first is use and ownership of documents. And we have a few things we want to discuss. First is ownership. And ideally, you want to maintain ownership of your work product. But it's rare that I see that anymore. Usually, the client wants to have ownership of your work product. And that's not a deal breaker from a risk management perspective. But you want to consider a few things. If you're going to transfer ownership, you want to make sure that you get paid for services rendered before you transfer that ownership. You want to limit the client's use of your work product to the use and occupancy and maintenance of the project for which they were created. And you want to require the client to indemnify you if they use your work product without your authorization or involvement. Copyright is different. Copyright can be very complex, but the thing to know for today's purposes is that transferring copyright is much broader than giving ownership. If you transfer copyright to your client, that means that the client can reuse whatever that work product was at its sole discretion, and you forfeit your rights to reuse your work product, including, and this is one of the scary parts, your standard details that may be incorporated in that work product, unless you add language to your contract preserving that right. And in the next slide, I've got some stock language that we'll look at briefly. So copyright, I mean, we could spend a whole day talking about transferring of ownership and copyright. But keep in mind that if it starts talking about your work product is, quote, works made for hire, that is transferring copyright, and it is a much broader transfer than merely granting ownership. And you want to make sure that you're contractually protecting yourself, and again, we'll get to that. Electronic documents. You have the same types of issues with transferring ownership of e-docs as you do with hard documents, but you have some additional issues. You should clarify that electronic documents can be unintentionally altered. They're for informational purposes only. They're not an end product. and you're not making warranties about their fitness or for whatever use the client may intend to use them. If a third party has requested your electronic documents, and sometimes this happens where your client will contact you and want you to release your electronic documents to a third party, you can do that, of course, if you so choose, if you're not contractually obligated to do so. But if you do, you should demand and receive a release and an indemnity from that third party before you turn those documents over. And if the third party won't give you this release and indemnity, then we recommend you don't turn your documents over to them, obviously, unless you're somehow legally required to do so. We also recommend that you put a waiver and release language right on the documents themselves and remove your stamps and signature blocks. Lastly, I want to talk about maintaining confidentiality of the client's documents. And these confidentiality provisions, or lots of times you'll even have it be a separate exhibit, it's pretty common. It's not a deal breaker to maintain confidentiality. In fact, it's pretty common, as I said, but that obligation to keep information confidential should not be absolute, and there should be some exceptions to your duty to maintain the confidentiality. These are the three main exceptions. One, if the information is in whatever form in the public domain. Two, if you're required by law to produce documents. And three, if it's reasonably necessary for you to defend yourself in a claim. Okay, I think that's all I wanted to say about that. So this is the provision that I referenced. If you do decide to transfer your copyright, and I recognize that there are a lot of words on this slide, but we'll briefly go through it. If you do decide to do that, it's important to contractually protect yourself. So this first part says that if the client uses these documents or creates a derivative work, they're going to remove your seals and logos from the documents. They also agree that any kind of use or modification without your involvement is at their risk. They're going to waive rights against you and agree to defend and indemnify you from all claims arising from that use. And then the last part, the last two sentences are the preservation of your right to use your standard details. And again, we mentioned how important that is, because arguably if you transfer your copyright but you do not explicitly retain this right to use your standard details, then you could be in a situation where you used your standard details and the client sued you for copyright infringement. So keep that in mind. The ideal situation is you don't transfer copyright, but if you do, you want to have some protections in place, and this is an example of language you can use. Next is limitation on time to bring claims. And there are a few things we need to speak about here. The time limit for a party to bring a claim, and we'll talk about basically a party bringing a claim against you, because you're usually the defendant in these types of issues, is governed by these three main things: statute of repose and statute of limitation, and we'll chat about that, contract and case law. Statutes of repose are state statutes that protect design professionals because they set a maximum time that claims can be brought against you. They're in your benefit. It's a good thing to have statutes of repose. The time clock starts to tick from a fixed point on a project, and usually it's substantial completion or the date of occupancy. These statutes are different than all the states. Not every state has a statute of repose. For example, New York doesn't really have a statute of repose. And they range in time frame from 6 to 12 years for negligence, although some states it is even longer than 12 years. So because these start to tick from a fixed point, usually substantial completion, we recommend that you keep certificate of substantial completions permanently as part of your document retention program for statute of repose defense in the event that that's applicable. Statutes of limitation are also state statutes that specify the time limit to bring claims. Negligence statutes of limitations usually run 2 to 4 years, so they're shorter, but the time when the clock starts to tick is not the same setup as it is for statutes of repose. With statutes of limitation, the time often starts from when the plaintiff discovers the harm or when they reasonably should have discovered the harm that caused the claim, and that's known as the discovery rule, so when they should have discovered it. So it could be that they didn't discover or it wasn't reasonable for them to discover the harm for much longer than just the 2 to 4 years. Next is contract. You can modify the time limit. You can modify the statutes by your contract. In some of the industry standard documents, for example, the AIA, in the 2017 version, they set a max limit as 10 years, which can be beneficial depending on the state that you're practicing in. Contracts may also have language saying that the plaintiff can bring a claim, quote, as long as the contract is in effect. That can be problematic. Let's say you have a master contract that renews automatically. Arguably, that would extend the time as long as that contract's in being renewed. And then the last way I want to talk about that the time limit can be modified is case law. And here we have a Latin phrase which translates to "no time runs against the king." And it's a super old concept, but it was recently, as recently as 2012, employed in Connecticut. So those of you who practice in Connecticut, you probably know about the case where the Supreme Court allowed the state of Connecticut to sue the professionals long after the statutes of repose and limitation had expired. And the court essentially said, hey, this "no time runs against the king" concept has been on the books for ages and ages. We haven't changed it, and it's still in effect. So you want to have some knowledge about the jurisdiction in which you're practicing. Okay. So contract assignment issues is the last concept that I wanted to address today, and I can't see the questions, so I'm assuming that there are some, and Daryl will have to ask them when we finish this section. Contract assignment documents, it will be presented to you by your client, and the clients will usually tell you that this is an emergency, you can't change these, they came from the lender, and you need to sign this yesterday. It makes sense that lenders want these documents signed because in the event your client, the borrower, defaults, the lenders want to make sure that the project keeps going forward with you still providing services so there's no interruption in the project. We get that, that's reasonable, but the problem is that often these documents are unreasonable. Here's some things to think about. The lender documents, the assignment documents, if you had to boil it down to the concepts to keep in mind, is these first two checks. It should not expand your obligations or responsibilities that you had under your contract with the client, and it also should not give the lender greater rights than your client had under the contract. And we're going to think about when that can come into play. And where you see it often is that these lender docs will try to say that the lender can use your documents in a broader way than you had previously negotiated with your client. So you want to always tie that back to your contract and say, because it will always say, well, I shouldn't say always, it will very often say that the lender can use your plans and specs and work product. And I always add language saying, to the extent that the client had such rights under the professional services agreement. These lender docs sometimes want to slip in warranties or guarantees about what you're doing. Just like with your contract, you can't have those, so you'll want to delete those. Sometimes there is language saying that you'll give expansive rights to the lender if you want to suspend or terminate the contract. So again, that's an area that you want to compare to your professional services agreement to make sure that you're tying it back to your contract. And then one of the biggest issues is making sure you've been paid. The lender, if it's going to take this over, they need to fully step into your client's shoes, including paying you if you're not up to date on your payment. And very often, language in these assignment docs will say that the lender doesn't have any obligation to pay you for outstanding invoices. So the client is telling you, okay, we're assigning this, we're assigning your contract to the bank. Now the bank is your client. We're out. We have no more obligations to you. And the bank is saying, yeah, we're going to step in, but we're not stepping in for what you did with your client. So if your invoices are not up to date, you could be in a situation where you're kind of in limbo and you're out money. Again, industry standard documents, I know this is an engineer group, but to the extent that your architect clients are using AAA docs and then using the C401 with you, keep in mind that in 2017, the AIA added some nice language saying that the client, when they do step into when the lender steps into the client's shoes, it's including that taking over any payments due to the professional that the owner owed prior to the assignment. And that's nice language because typically you're not going to have a problem continuing to give services, but by rights you should be paid for what you've done. You shouldn't be out money based on your client's default and the assignment issues going forward. The other thing I like to make sure of with assignment in your contract, the language sometimes will say in client proposed provisions that you can assign, you absolutely cannot do that, but the client can assign, which is not a deal breaker because it kind of makes sense. They want to make sure they've hired you, that you're the one who's going to be doing the work. But the second sentence, when they say, if the client assigns, you will agree to execute any and all documents presented to you within 24 hours of presentation, and you will agree that to make any changes to this agreement if the lender so requires, that kind of thing. That should be deleted or at least heavily modified. And I like to add language saying that you are not required to sign or execute any document if, in your sole discretion, it increases your obligations or impacts your professional liability or commercial general insurance policies. And that arguably gives you a little bit of protection that if you're presented with one of these documents from the bank that's onerous and you're getting pressured to sign this thing, you can go back to your contract and say, look, we've got language in here that says we don't have to sign anything that is expanding our rights or putting our insurance in jeopardy. Without that kind of language, if you leave the kind of language that clients sometimes put in there saying that you agree that you'll sign each and every document, it's a harder sell to make saying, hey, we're not going to sign this because your contract says that you will. So keep that in mind. Oops. There we go. So I want to spend a minute, bonus topic, email protocol, recognizing that we had some technical difficulties this morning. Well, this is kind of appropriate. Email. Think before you send it. you should not be putting your feelings in it. It should be objective, factual, professional. Don't put expletives in your emails. Don't send them when you're angry. Draft them, but put them in a draft box and come back at a later time after you've had a chance to be a little bit more calm to look at what you're sending out. All caps and all bolds, in my mind, is shouting at people. I probably would recommend against that unless there's some really important reason for you to do so. Humor, unfortunately, does not translate all the time in emails, so humor and trying to be funny is probably not advised. Spell check, super important. Obviously, you want these emails to look professional, and also if you've got spelling errors or punctuation errors, it could dramatically change the intent of your statement. Reply all and long email chains. This is a really dangerous thing, and when you think about what you're doing with email, if you're hitting reply all, that means obviously it's going to everybody, and there may be some things that you don't want everybody to see. Long email chains, I think, is even more dangerous because I don't know about you, but when I get an email chain, I just scroll right to the bottom and I start reading from the bottom up because that's the only way you can get an understanding. But the last thing you want to do is forward a long email chain that has something in it that you absolutely never wanted to send to the person that you're sending your email to. So pay close attention to that. Autofill in email addresses. Unfortunately, I think many of us, myself included, have accidentally sent an email to the wrong person because it autofilled, and names can be similar, email addresses can be similar, so be super careful with that. And then lastly, don't forget about using your phone. If you have something to say that should not be in writing, and the kind of idea I always put out there is if you would not want an exhibit blown up in the courtroom for your mother and your priest to see it, then you probably don't want to put it in email. So don't forget about using your phone. Walk down to that person's office. Talk to them in person. If you do use the phone, though, and it goes to the message service, don't leave a message because that would be discoverable. So you kind of defeated your purpose by trying to use it. So, email protocol, these things are basic, they're common sense, but I always think that they bear repeating because we're so deep into the electronic age where sending a hard copy letter, which is, typed up and proofed and re-edited and, checked for tone and spelling and punctuation and everything, those days, unfortunately, or fortunately, depending how you look at it, are gone. So you want to make sure that you're being professional and appropriate with your emails. Okay. For those of you who are insured with Beazley, this is the website address for our risk management website, and I would encourage you to go on. It is password protected, so you'll need your policy number, but it's where we house all of our risk management materials, our past webinars that Beazley puts on quarterly, lots and lots of information on contract review and contract provisions, our newsletters, et cetera. So take a peek at that if you have not. And then I think we're up to questions. And Daryl, I'm not sure, was Jim able to join?
He was able to join by audio. I am actually going to ask Jim if he would start speaking, and I will tell him when we can hear him.
Okay.
Yeah, and he is.
Good afternoon, Daryl. This is Jim. Can you hear me?
Yes, Jim, we can hear you.
We can hear you.
Well, very good. It's nice to be able to join today, and briefly before the opportunity to ask questions, I would like to say to everybody who has joined us today on the call, technological issues aside, we want to thank you for being a part of today's webinar, and we hope that to this point you found it to be very informative and helpful. Clearly, I want to thank IEEE USA for being able to sponsor the webinar, and certainly the IEEE for providing us with a wonderful opportunity to be able to speak to you today. We, again, hope that you find some value and some takeaways from this webinar information. I would also like to thank Colleen Palmer, who, again, Colleen, a pleasure to work with you again, and we appreciate the knowledge, professionalism, and level of expertise that you always bring to these very valuable webinars. So that said, Daryl, I will turn things back over to you, and if there are questions from the attendees in the few minutes remaining, we'll feel free to allow those to be addressed at this time.
Great. Thank you so much, Jim. Colleen, yes, there were some questions. First question is, it came, I think, while you were talking about indemnification. It just says, how about willful misconduct? With a question mark.
Yeah. So I'm assuming that that is in the indemnity. I delete willful misconduct because it is an intentional-based act, and professional liability insurance is a negligence-based policy. So arguably, it would not be covered, or there could be coverage issues with that. So I encourage you, even though it's going to be difficult negotiating, but you are going to have to take out your red pen when it comes to indemnity, because the indemnity language over the years has not improved. I think it has at least stayed the same level of onerous, but I think often it has gotten significantly worse, more convoluted, more confusing. So things like willful misconduct, intentional misconduct, gross negligence, that's another one where people can get tripped up because they see the word negligence and they think, okay, well, that's okay, I got that. But gross negligence is an intent-based act, and this is something that lawyers would know, but you certainly wouldn't be expected to know that as a design professional necessarily.
Okay. There was a follow-up to that. It says, my CSA indemnifies both ways, me to them and them to me. Okay?
Maybe. As we talked about on that slide with the bullet points for indemnity, you want to make sure still that whatever I'm sorry, was this, let me clarify, was this contract where the engineer is retaining a consultant or being retained? If it doesn't say, let me talk about both. So if you are being retained by your client and you have a mutual indemnity, you still want to make sure that you don't have a duty to defend, that the indemnities is limited to your client and its officers, directors, and employees, and that your obligation is limited to the extent damages are caused by your negligence. And I'm okay if the client obligation to you is limited in that way too. It's more important that your obligation be appropriately based, because again, it's more likely that you're going to be asked to indemnify your client than your client to indemnify you. Now, in the case where you are retaining a sub, and you are in effect the client and your sub is your sub, I would make it just that your sub is going to indemnify you as the client. I wouldn't easily say you're going to indemnify your sub.
Okay. The next question is, can you re-explain, clarify recommendations regarding electronic documents?
Yep. So electronic documents, the issue with them is that because they're electronic, they can be modified unintentionally or, so you can't tell that they are. So you want to make sure that in your contract, if you are required to provide your electronic documents, you're still getting paid first. You're still limiting the use of the project for which they were prepared. But the additional issues with eDocs is that you want to make sure it's clear that hard copy controls, the electronic documents are just for informational purposes, and you're not giving a warranty that these things are accurate because of the fact that they can be changed because they are electronic.
Okay. Moving on, it says, can you expand on the non-binding mediation recommendations?
Yeah. So non-binding mediation is a process, a dispute resolution process, where the parties get together with a mediator, and attorneys are usually there, and the parties present their arguments. Typically thereafter they're separated, and the mediator will meet with both sides. And good mediators are not just gophers that take back numbers back and forth. They actually are experienced in the construction industry and the issues at play in your claim, and they can be pretty frank and honest with each side in the private breakouts to say, whether or not they think that the mediation is moving down the right path, type of thing. Now, with mediation, ultimately, if the parties just cannot agree, then they walk away. They don't have to reach an agreement in mediation, and they can then proceed to, we like litigation as opposed to arbitration. Mediation, though, because if you go with good faith that you really do want to resolve the situation, we found, there's stats out there from various groups, but it's as high as 80%-ish can settle in mediation, or after mediation, a few days later, the parties get back together. So it's a good dispute resolution mechanism because of all the things that I just talked about, but also because it can preserve the relationship. It's confidential, and it just has those kind of more negotiating aspects to it as opposed to when you get into binding dispute resolution.
Okay. Next question is, he said, if you are retained by your client in an arbitration between them and a contractor, are there any things to be careful of?
I don't know what they mean by that.
Yeah.
Okay. I don't really know what that means, so I don't want to comment on it. I mean, we talked about the issues with arbitration. If they're talking about being joined in an arbitration, you want to make sure that you are able to fully participate in that arbitration, including the selection of the arbitrators. It's an important part of arbitration. Okay. I don't know if that answered the question or not, though.
Maybe they'll follow up. It says, do I need to continue my PL insurance after I retire or stop consulting?
It depends. That's something you should talk about with your broker.
Okay. And forgive me if I butcher this word. It says, what about cryptographic signed electric documents?
I don't really know what they mean by that. If they mean whether or not, I don't think they mean this, but if they mean whether or not e-signatures are valid on contracts, the answer is yes, but I'm not sure what else they mean by that.
Okay. Well, believe it or not, that was the last question. The only other thing that came in was the person, and someone says, I think the person means using something like DocuSign to sign an agreement.
Yeah, and that's fine. We're in it now, folks, with the electronic everything, and often contracts will say, kind of the last provision will say, this document can be signed electronically in different parts and that sort of thing. So yes, that is considered legally signing. In fact, I just closed on a house and we did everything signing electronically. It can feel a little awkward though, because it doesn't seem official like with your pen. But yes, that is the new wave.
Okay. I don't know if you have a few more seconds. Someone asked, I'm not quite sure what they mean. It says, any recommendations for engineering companies that perform testing? But I'm not quite sure what they mean by that.
Yeah, I think that is more than this session.
Yeah, let's see here. All right, it just says, I'm not familiar with lender contract assignment issues. Please give an example of business situation where this occurs.
So this happens when the borrower, which is probably, we're talking to engineers, so typically architects get these assignment documents and then some, they'll flow down maybe to the engineers, but usually it's if the client who borrows or wants to borrow money from the bank defaults, or they do these things before there's a default just to get it all teed up, that if they default, the bank will be able to have those contracts that the borrower has be assigned to the bank. So essentially, the project will continue, but instead of the client being the owner of the project, now the ultimate client is the bank. And these lender documents can be more or less complex in both language and length. I've seen them be 30 pages, I've seen them be 5 pages, so it totally depends.
Okay. All right. Well, I think that was our last question. Colleen, I want to thank you so much. I want to also thank you for bearing with us through our technical difficulties. I want to thank all the people who are signed on and participated that bared with us through the technical difficulties. There have been numerous questions regarding will the presentation be available in terms of our PowerPoint slides. I will discuss that with the speaker, but we have recorded the webinar, and it should be up within the next day or two on the IEEE USA website. I can probably send that out directly to you once the recording is available. That is really about it. I want to thank everyone, unless, Colleen, you had any last questions. Also, I should also thank Lynn Coblin with IEEE membership discounts for helping to put on this webinar as well for us. So
I would just add my own thanks for having the opportunity to present to your group, and this is a topic that's certainly near and dear to my heart, so I hope it was informative, and I thank everyone for bearing with us and peering behind the Wizard of Oz curtain as we got set up and bearing with us while we got rolling. So thank you.
All right. All right. Well, thanks everyone so much. I'm going to end this webinar, and I'm going to end this webinar, and someone just asked a question about certificates. You can get certificates from the IEEE USA website dealing with webinars. If you have questions about it, just shoot me an email, and I'll direct you on how to get a certificate for attendance of this webinar. All right. Thanks, everyone. See you so much. Bye-bye, Colleen. Thanks so much.
Bye-bye. Thank you.
Bye-bye. Bye-bye.